From what I can learn online, Flavio Zutti was quite a character who arrived in the great post-war wave of immigration from Europe. His father was a fashion designer and he followed the family trade, starting out with a suitcase and £20. He built up a company, Zutti Pty Ltd, which focused on men's suits, and by the early 1970s, the factory employed dozens of people. A road accident in late November 1978 left him in hospital until January 1979. He would never again be able to return full steam to the business. As a result of his absence, there was interference with the finalising of the 1979 fashion line, and a major deal with designer Trent Nathan was in danger. Zutti sued for his own injuries, and Zutti Pty Ltd sued as his employer for the loss of his services. The defence argued that the company was not entitled to compensation because he was the managing director, but he was also an employee, paid a salary. Justices of Appeal Glass and Samuels said, "We agree with the trial judge that the plaintiff company was entitled to sue for damages for the loss of the services of its employee, notwithstanding that his services were not of a menial nature, and that Zutti was an employee of the company, notwithstanding that he was its de facto managing director." The recoverable damages of the company measures the loss it suffered as a result of being deprived of the services which, but for his injuries, Zutti would have probably continued to render. The difficulty was trying to work out just what those losses would be. The rules of causation applied to this situation in the same way that they would apply to any other negligence case. The loss must be caused by the breach and not too remote. There was evidence that this business was struggling by the late 1970s, and given the substantial impact which a managing director would ordinarily have on the business performance, it was really difficult for the judges to work out the losses associated with Zutti's absence from those just simply caused by the trading conditions. The court ultimately settled on a figure of about $545,000. From this case, we learn that a corporation can potentially sue for the loss of the services of an employee when those services are removed by a defendant's negligent conduct.